go to a Paraguayan court. I'm not saying that Paraguayan courts are good or bad. I don't know. I've had some experience in Paraguay, but not enough to have an understanding of that. But the Spanish investor says, if I go here to Paraguay, and the government took my cement plant, how can I go to the government, which is the courts are part of the government, obviously, and say, give it back, you were wrong, and expect for the courts to say, yes, the superintendent of the environment and the ministry of the environment were wrong. Give them back the cement plant or the mining or whatever. So the thinking in the World Bank was that we needed this system, we needed a system where there could be dispute resolution, and that's where the Washington Convention comes in. The ICSID Convention, the International Center for Settlement of Investment Disputes. And then we talked about, you and I talked about how that convention provides a place and a set of rules for dispute resolution, and the BIDs provide the substantive protection to be enforced in that venue, if you will. Do you remember that? One of the things that we also discussed was, if in fact there is an asymmetrical situation where once there's a problem here and the Spanish investor feels that there's a problem and the investor goes to you and you give them the advice that you gave them yesterday, which is to file an international investor-state arbitration. You said under the exit rules, and you said alleging that all of these things, that you were expropriated, that you tried the judicial system and it didn't work, there was denial of justice, it didn't work at some egregious, horrible level. The fair and equitable treatment was not accorded to your investment. You were treated less favorably than the treatment accorded to nationals of the host state, meaning Paraguay. And then you looked at most favored nation clause, and you said, gee, Paraguay accords to other countries certain types of treatments and certain types of protections that's not in our bid, so we'll take that too. We'll take that too. And we said once that happens, and you look at the bid with care, you find that the respondent, Paraguay, has all of the obligations, and that the claimant under that bid, really, when you look at it closely, has very, very few obligations. Basically, to follow the law. Basically, to follow the law. To be a law-abiding entity or citizen, period, end of story. And we said, so what is bilateral about it? We said, well, it's a bilateral agreement to agree to have a unilateral agreement once a request for arbitration is filed, once a formal investor-state arbitral proceeding ensues. The question then became, ladies and gentlemen, and we're going to get to public purpose very soon, the question then became, should the bilateral investment treaties be somehow interpreted or construed so that once you have a formal proceeding, the landscape is a little bit more even? And I will leave you now with that question. We will return to it. I leave it now because I want you to think about it somewhat. And I want you to think about this problem. Remember the problem of the square area circle? Yes. We still have that problem. This is the problem. We're trying to square the circle. We're saying the Spanish investor under international law has every right to have his or her investment protected. That's a sacrosanct right. But we also said Paraguay has every right to engage in regulatory sovereignty. And we said not only is that a sacrosanct right of equal dignity, But it's an existential right. Why? Because states cannot operate if they don't engage in regulatory sovereignty, if they don't issue judicial decrees, if they don't admit legislation, if they don't generate regulatory pronouncements. Remember we said that? And we said, but sometimes the regulatory sovereignty, the regulatory activity, as we saw in this example, remember? And we're going to talk about it. I put numbers to it because I think when things have numbers, they're understood a little bit more clearly. And I'll explain that. We said the regulatory activity affects the value of that property. And that's how I want you to understand this problem always in the investor-state arena, investor-state arbitration. You always have a regulatory act and you always have property. And the question is, how do we understand whether the regulatory act is permissible? What kind of concepts can we use to identify whether that regulatory act is correct? And one of the things that we said was that public purpose is one of these vehicles, believe it or not. One of them, not the only vehicle, of course. One of them. Because one of the problems that the system has is that we cannot take the position that a state will be punished in the form of having an adverse arbitration award in the hundreds of millions of dollars. And in fact, taxed or fined for merely engaging in regulatory sovereignty. The state must engage in regulatory sovereignty. It has absolutely no alternative. And this regulatory sovereignty undoubtedly will affect foreign investments. That must be, as a matter of law, protected. So we have to think of a way to identify when is that regulatory sovereignty wrong. And that takes me to where I want it to be, which is that we said in the first of the 4 points of our framework, and remember that I only got to the second point. Do you remember any of the stuff I was saying? Let me ask you another question. Is this the same group of people who came here yesterday? The first point that I said, and this is absolutely analytically critical in this field, I think, and my colleague there thinks as well, but then he'll be Pedro. He's the Italian guy here with the glasses. We feel that the first point, we said that international law has to be true to itself. And we said that statement means nothing unless we can explain what it means. And I said what it means is the following. It means that international law cannot rely upon domestic law principles of contract, of property law, remember that? Or of court law, the law of civil liability where there's no contractual. And we said the reason, we said we have to bring in macroeconomic concerns, we have to bring in microeconomic concerns, we have to bring in proportionality, we have to bring in distributive effect. We talked about one of the Czech Republic awards. One of the awards against the Czech Republic was for $350 million that exceeded, I don't remember if it was for 1 year, 2 years, or 4 years, it may have been for 4 years, its annual health budget. So we have to look at the distributive effects. We also have to see what the investment actually represents. And we're saying the current regime ignores all of those considerations. But I want to make it a little bit clearer because I think I failed in explaining why that's important. That's important because, well, how many people here have taken the law courses on contracts? And how many, thank you. Thank you. Are you a 1L or a 2? How many people have taken courses on tort law? And real estate law? Corporate law? If you look at domestic law, ladies and gentlemen, Domestic law was not formulated to identify instances where a regulatory act is impermissible. Do you see it? It doesn't fit. You need a new paradigm, just like you needed a new geometry for the squaring of the circles. That new paradigm really is not all that new. That new paradigm has to do with simple respect and integration of the foundational economic international law principles that have been abandoned, plus a policy of making sure that the principles apply, comport with the aspirations of international law. The second principle was the issue that we discussed concerning expropriation. And we said that every state has a right to expropriate, even foreign investments. Every state has that right. We said that. But to have that right, you have to exercise it correctly. And public international law is very clear on what those elements are. Does anyone remember those elements? Come on. That's the way I like it. 5 hands, yes.
And there were 4 principles. First of all, it mustn't be discriminative.
It must be what?
It mustn't be discrimination.
Yes, she said non-discriminatory, yes.
And secondly, there must be compensation for it.
Yes.
Thirdly, there have to be a public purpose. And
Of course.
And one more thing, I don't remember.
That's fine, you did great. Yes.
It has to comport with due process.
Due process of law. This is a super group. That's what it must do. But then we said, gee, if you have this asymmetry in the negotiation, the relative positions of power before entry, that's going to change it. And we saw something very curious that was counterintuitive. The 1959, the first bilateral investment treaty ever between West Germany, which happens to be between West Germany and Pakistan. And we said, if you look at that bilateral investment treaty closely, you will see that the expropriation provision does not have a due process requirement, and it does not have a discrimination requirement. It just has public purpose and compensation. And we found that odd because in that relationship between West Germany and Pakistan, the reality is that Pakistan would have been the host state, of course, and West Germany, a much more industrialized state, would have likely have been the claimant. And why would West Germany, with more negotiating power, take away from Pakistan obligations that it has to comply with and make it so simple? What made the problem worse for us was that the problem highlighted and made even clearer for us the challenge with public purpose. Because we said that the public purpose that we know has the deficit that it is whatever the state defines to be public purpose. It is a vacuous, bankrupt doctrine that is subjectively rooted. And therefore, it underscores a test that can always be met. And a test, ladies and gentlemen, that can always be met is meaningless. By definition, it doesn't work. It's mathematically flawed. So we have to do away with it. There was a third point, the third framework point that we need, which we never got to, and now we're going to get to it, is that states must prove public purpose. If we're going to advance, states must prove public purpose as a matter of evidentiary showing. Now, here we need some flexibility. We need some flexibility. I think that we should give states the burden of proof, but I think it should be a rebuttable burden of proof, of course. So I think that there should be some sort of sliding scale, where yes, you know, you have to prove, it's not that we're assuming that you're wrong, but you have to prove that you engaged in this measure for the reasons that you stated. Professor Yüksel, I think, asked yesterday, well, give us examples of proportionality. This is a perfect example of proportionality. The state should be able to prove that this was the most economic way of doing it, the most efficient way of doing it, the least intrusive in terms of collateral effect. Here's where we say, let's give public purpose some meaning. The issue, ladies and gentlemen, became, by having a public purpose with meaning, with an objective standard, with a requirement, are you hurting host states? Are you hurting developing states who are likely to use the subjective public purpose standard as a defense? Remember that question? And I said to you, don't be fooled, that argument is very, very superficial. A public purpose with content can only help developing states. Because you want to give states a valid, legitimate reason for acting. A valid, legitimate reason that also, ladies and gentlemen, provides the semblance, the appearance of legitimacy to the international community, which PS happens to be watching. This is critical. So it's counterintuitive. But yes, having a substantive doctrine rather than a make-believe, pretend doctrine matters. The fourth point that we didn't talk about, and that's the fourth and final point in the framework. It's important. It has to do with the role of public purpose in human rights, which is an area of law that I find to be fascinating, important, extremely underdeveloped, and underappreciated. I think that public purpose, and I'm not going to talk about this much, if I'm ever invited back after these lectures, which, you know, I probably won't, but if I'm ever invited back, I'll talk to you at length on this marvelous and incredible area. Public purpose, I think, is the mechanism, the conceptual tool that allows us to justify normatively and not emotionally, objectively and not subjectively, a hierarchy of human rights. Why? Let's think for a second, okay? Let's think about this for a second. If you think about what the situation that we have here, even though these are two countries, the reality is that chances are 95% or more of the time that this is an individual of a national of the signatory state. In our example, Spain. It's an individual entity or a natural person. What public purpose does, the broader the public purpose, the more restricted the rights of the individual, the more powerful the rights of the state. So public purpose, if you have a broad, all-encompassing public purpose, which is what we have in many industries, and I'm going to talk to you later, of the treaty that you have, that Turkey has, the Republic of Turkey has with Azerbaijan. Very interesting. But I'll show you some things from a real treaty close to you so you can analyze it. If you have a broad public purpose, the individual rights are going to be more restricted. The state will have greater ability to interfere with individual rights normatively and legitimately. If you have reasonable public purpose or a more a narrower public purpose, a more detailed public purpose, narrowly construed to fix certain problems and provide the state reasonably with regulatory powers within the context of the issue at hand, then everyone will profit, everyone will prosper. It'll work. How does public purpose figure into the human rights realm? Well, public purpose, if you attach public purpose to human rights analysis, public purpose will lead you to the inevitable conclusion that there is a hierarchy of human rights. Now, when you read a human rights convention, if you read the American Convention on Human Rights, which I'm very familiar with, the European Convention on Human Rights, or the African Charter on Human and Equal Rights, you will see that they really don't have a hierarchy of rights. All rights are human rights. That's very bad, I think. That's my opinion. That's my doctrine. For human rights. Because if you have a hierarchy of human rights, that means that the relationship that the state has to all the human rights must be the same. It's mathematics again. It's all math. It's the same. But let's think about some of my favorite human rights. How about the right to be free from torture? How about the rights of children? How about the right to have a name? Versus, for example, the right to vote. The right, important as that right may be in some places. The right of assembly. The right of freedom of speech. The right to be ambulatory to travel. They're different. Public purpose says, well, state, maybe you have, in a certain situation, could be a state of emergency, could be a state of terrorism, you can act and suspend voting, or cancel the elections, or modify and limit speech for a temporary period of time because there are inflammatory issues that cannot otherwise be controlled as a matter of basic public order. And you can also limit, under certain circumstances, and for a limited time frame, the freedom of assembly. We can see reasonable scenarios for this type of exercise of regulatory sovereignty. But ladies and gentlemen, I challenge you here. Tell me one instance where the state can say, no, my citizen, you're not free from being tortured. You're not free. Because if I don't torture you, or someone, your boss doesn't torture you, you're not going to behave. You're not going to do things the way you're supposed to. Or, no, you don't have a right to have a name. You're number 357, report as such case tomorrow. Or, no, children don't have rights. You're too young to give a shit but yourself. You can't have it. Public purpose says there's no public purpose that justifies it. It won't work. But without public purpose, you won't have the state, and then rights, and then different orders of magnitude. That order of magnitude, that's the hierarchy. Not to be simplistic, but trying to make it as simple as possible, which is a different thing. Do you see what I'm talking about? I want to...
Can I ask a question?
Yeah, please. You can ask two questions.
So then, where do you put the fact that we have restrictable and unrestrictable fundamental rights and freedoms, like right to be free from torture, right to life, freedom of belief? I'm talking about it in a circle. There are unrestrictable fundamental rights and freedoms under many, almost all constitutional democracies. But still, there is no hierarchy between these fundamental rights and freedoms and others. So, is it a matter of public purpose, or the technical differentiation I'm talking about?
Well, I think it's both. I don't think you can ignore a technical differentiation because ultimately it depends on what type of normative basis you have for calling something restricted or unrestricted. That I think is a very, very serious issue.
Okay, so then the question comes as to whether you would call or define proportionality is an objective standard of application of public purpose.
Yes, of course. And it has to be. Because, again, when you have proportionality, what you're really saying is that you can justify to everybody in the same way. Points of our framework, and remember that I only got to the second point. Do you remember any of the stuff I was saying? Let me ask you another question. Is this the same group of people who came here yesterday? The first point that I said, and this is absolutely analytically critical in this field, I think, and my colleague there thinks as well, the man will be pleased. He's the Italian guy here with the glasses. We feel that the first point, we said that international law has to be true to itself. And we said that statement means nothing unless we can explain what it means. And I said what it means is the following. It means that international law cannot rely upon domestic law principles of contract, of property law, remember that? Or of tort law, the law of civil liability where there's no contractual. And we said the reason, we said we have to bring in macroeconomic concerns, we have to bring in microeconomic concerns, we have to bring in proportionality, we have to bring in distributive effect. We talked about one of the Czech Republic awards. One of the awards against the Czech Republic was for $350 million that exceeded, I don't remember if it was for 1 year, 2 years, or 4 years, it may have been for 4 years, its annual health budget. So we have to look at the distributive effects. We also have to see what the investment actually represents. And we're saying the current regime ignores all of those considerations. But I want to make it a little bit clearer because I think I failed in explaining why that's important. That's important because, well, how many people here have taken the law courses on contracts? And how many, thank you. Thank you. Are you a 1L or a 2? How many people have taken courses on tort law? And real estate law? Corporate law? If you look at domestic law, ladies and gentlemen, domestic law was not formulated to identify instances where a regulatory act is impermissible. Do you see it? It doesn't fit. You need a new paradigm, just like you needed a new geometry for the squaring of the circle. That new paradigm really is not all that new. That new paradigm has to do with simple respect and integration of the foundational economic international law principles that have been abandoned, plus a policy of making sure that the principles apply, comport with the aspirations of international law. The second principle was the issue that we discussed concerning expropriation. And we said that every state has a right to expropriate, even foreign investments. Every state has that right. We said that. But to have that right, we have to exercise it correctly. And public international law is very clear on what those elements are. Does anyone remember those elements? Come on. That's the way I like it. 5 hands. Yes.
And there were four principles. First of all, it mustn't be discriminative.
It must be what?
It mustn't be discrimination.
Yes, she said non-discriminatory, yes.
And secondly, there must be compensation for it.
Yes.
Thirdly, there have to be a public purpose. And
Of course.
and one more, I think. I don't remember.
That's fine, you did great. Yes.
It has to comport with due process.
Due process of law. This is a super group. That's what it must do. But then we said, gee, if you have this asymmetry in the negotiation, the relative positions of power before entry, that's going to change this. And we saw something very curious that was counterintuitive. The 1959, the first bilateral investment treaty ever between West Germany, which happens to be between West Germany and Pakistan. And we said, if you look at that bilateral investment treaty closely, you will see that the expropriation provision does not have a due process requirement, and it does not have a discrimination requirement. It just has public purpose and compensation. And we found that odd because in that relationship between West Germany and Pakistan, the reality is that Pakistan would have been the host state, of course, and West Germany, a much more industrialized state, would have likely have been the claimant. And why would West Germany, with more negotiating power, take away from Pakistan obligations that it has to comply with and make it so simple? What made the problem worse for us was that the problem highlighted and made even clearer for us the challenge with public purpose. Because we said that the public purpose that we know has the deficit that it is whatever the state defines to be public purpose. It is a vacuous, bankrupt doctrine that is subjectively rooted. And therefore, it underscores a test that can always be met. And a test, ladies and gentlemen, that can always be met is meaningless by definition. It doesn't work. It's mathematically flawed. So we have to do away with it. There was a third point, the third framework point that we need, which we never got to, and now we're going to get to it, is that states must prove public purpose. If we're going to advance, states must prove public purpose as a matter of evidentiary showing. Now, here we need some flexibility. We need some flexibility. I think that we should give states the burden of proof. But I think it should be a rebuttable burden of proof, of course. So I think that this, maybe if we change the paradigm as the two mathematicians in 1882 to a Lomashevsky type model or a Sakari type model, then you have a different situation. But even there, we'll have an objective understanding too. Everything will relate to itself. Ultimately, when I say that we're trying to objectify, what I'm trying to say, ladies and gentlemen, is what? We want transparency to be underlying all of these documents. Why don't you take a 15-minute break, please? Thank you. The question becomes, ladies and gentlemen, when you look at this public purpose doctrine, and I want to talk to you a little bit about the historical part of it before we go back to the descriptive part. So what we're going to do is we're going to look at the historicity of the doctrine, and then we're going to talk about how we test the doctrine. Then we're going to go back to our question, the question that we posed before. How do you transfer risk? How do you transfer rights to the host state so that this can be more bilateral and more equitable? You understand? But first we're going to look at the historical approach. We started, very briefly, we started looking at public purpose, and in looking at it, I don't want to erase any of this stuff, but I guess it doesn't really matter. At some point. We started looking back. Where do we find it? Where do we find it? And we found public purpose first in classical, pre-classical Greece. Actually, we found it in the Greek of Homer, in the city-states. And we found that the word that was used, well, first of all, we found that the way public purpose developed in an international, if you can call it that, context, with the taking of property, had to do with the taking of slaves. And this taking of slaves, we saw two things. One, that it was justified by public purpose. And the second thing we saw was that it was geographically tied. It had an inwardness-looking aspect to it. And we also actually found a third item that's very important. We found language to be very important. So public purpose begins with an inward-lookingness, geopolitically tied, and with the parochialism of language as the conceptual category. Indeed, the word that was used by Homer is demos for the masculine and demos for the feminine. But once you move from here, and this is a word that was used for slave in exchange for public purposes, this word mutated somewhat. It mutated into the word as more and more slaves were being taken by the Greeks. The word mutated to the word anthropodon. And the word anthropodon, who speaks Greek here? You, what does it mean? I mean, the pronunciation is probably horrible.
Anthropos means
Anthropos means man.
Yes.
Lune means woman, and Sophos knows other languages. But no, what? Anthropodon.
Anthropodon. Doesn't sound.
Anthropodon is the derivation of this word later. It means slave, but it really, if you break down the root of it, it means, not too loosely translated, plunder with feet. Commodity, a thing with feet. Because the act of enslavement for a public purpose entailed the dehumanization of the person and turning it into a thing. So it was very much tied up with the conceptual language of property, domestic, parochialism, inward looking. It's in that sense, it was very tied to the concept. In that sense, it was very tied to the concept of the word barbaros from the Greek, which was, of course, their word for any non-Greek was a barbaros, and in the English language, that word barbaros turns into the word barbarian. Every non-Greek was a barbarian. This also fueled the takings process. And in fact, the word in its infinitival form, barbarizine, epsilon, iota, nu, the infinitive, for the Greeks meant to speak non-Greek, but also to speak gibberish, garbage. It's an onomatopoeic word that the Greeks thought, well, every non-Greek language is blah, 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 blah. That's what they thought. So we see that public purpose becomes the instrument for the state to be able to engage, with only one exception that we'll discuss in just 1 second, in the taking of things, which is what a slave was. And geometry, and geography is critical to it. I have to square the circle in my mind. Got to take it out. Geography is critical to it because even a scholar crossing a geopolitical line, this is the scholar. Here, that scholar became a slave, just crossing that line. Now, public purpose was so ingrained in the justification of slavery that it was turned into an intuitive concept. A concept that you can just see and understand theoretically why it's right. because the slave was put to use for the greater good of the polis and the internal economy of the polis. It was almost an absolute right. And the extent to which it was practically non-challengeable is very important because it's related to the word treaty. The only exception for a slave is related to the word spundus, which is the word for a treaty. And it's also a word that's related to something that students in the United States know a lot of because they do it a lot. I'm not saying it's good or bad, I'm saying they do it. Drinking, libations. And the Greeks, at the end of the celebration of a treaty, they drank. They first said that it's for the gods, so they went like that a little bit, and then they drank a lot, they drank it all. But it's really for the gods, but they drank it all. I mean, that's squaring the circle too. But this shows you the only exception is with the word, if you were by treaty, the city-states had a treaty that had a clause that says you cannot pay slavery, then a person who crossed from one jurisdiction to the next was called ensponden in the treaty, covered by the treaty. And all the rest, where there was no treaty, was called exponden. So that the only exception to public purpose was something blessed by the gods. It was so important. A treaty. But other than that, public purpose reigns supreme. Now there's a scholar who wrote a book in the late 1800s, a very classical book in international law, called Henry Wheaton. You may have heard of him. And I want to share with you what Henry Wheaton says on this issue, which I think is very, very interesting. The name of the book is Element. If you ever read it, it's a wonderful book, and plus it's written in a very elegant English, the English of the first quarter of the 1800s, which was a romantic period in the language that was very rich. You can see that, not necessarily in the very ugly passage that I happen to pull out, but generally the book is extremely well written. It's called Elements of International Law, with a sketch of the history of the science. And it observed as follows. Thucydides has correctly stated the leading political maxim of his countrymen, that to a king or a commonwealth, nothing is unjust which is useful. The same idea is openly avowed by the Athenians in their reply to the people of Melos. Aristides distinguished in this respect between public and private morality, holding that the rules of justice were to be so sacredly observed between individuals. Let me repeat that. The rules of justice were to be sacredly observed between individuals. Now listen to this part. But as to public and political affairs, a very different conduct was to be followed. He accordingly scrupled not to invoke upon his own head the guilt and punishment of a breach of faith, which he advised the people to commit in order to promote the public purpose. The public purpose reigned absolutely supreme. I dare say to you that it is precisely that public purpose that has accompanied us to this day. And it's precisely that origin of public purpose that has not changed. That's why it's possible to find a public purpose and 3,000 treaties that means nothing. Now, if you move away from the historical and you want to test this doctrine of public purpose, we found that one way to approach this test would be to try to identify a paradigm that was mirrored or reflected public international law. And this paradigm, this example, this model to use as an experiment. After looking everywhere, my co-author and I decided to look at the NAFTA, the North American Free Trade Agreement. Have you heard of that? Does anyone have any experience with that agreement? Academic experience? That's good. Don't worry. You're going to know everything you need to know about for this class. The NAFTA is really, again, the North American Free Trade Agreement. It has 3 signatory states: the United States, Canada, and Mexico. All of North America. A lot of people forget that Mexico is part of North America. A lot of people think that it's part of South America. Of course it's not. It's part of North America. It's not part of Central America. But it happens to be part of Latin America, which is something completely different. The NAFTA we felt was important because the NAFTA has a variety of topics that's extremely broad. It is foundationally, primarily, a trade agreement and not an investment protection agreement. That's what it primarily is a trade agreement. The NAFTA has 8 parts, 7 annexes, and 22 chapters. And the NAFTA addresses virtually every conceivable area of trade that there is. Anything that you can imagine is dealt with the NAFTA. But the NAFTA also has 2 investment chapters. And one of those chapters, which is the principal investment chapter, is chapter 11 or the 1100s. And that investment chapter has a dispute resolution mechanism. But what that investment chapter has that is very, very important to us is that investment chapter in section 1101, subsection 4, has a very, very interesting element. It has a reference to public purpose that we think is very important. We're going to talk about it in a second. Assuming that I find a piece of paper that has the NAFTA on it. But it has that reference to public purpose. But the NAFTA also, beyond that, has its own case law, its own jurisprudence. And it's very jealous, the NAFTA, of its own jurisprudence. By its own jurisprudence, I mean arbitral awards that interpret the NAFTA provisions, the application of NAFTA provisions, of the standards of protection under the NAFTA. So it has that, which is extremely and exceedingly important for us. So in that sense, it has trade, it has investment, and it also has a dispute resolution section. And it has investment protection. It has in addition to having this jurisprudence that is very, very jealous and therefore very much a microcosm of public international law, the NAFTA has reservations and exceptions. These reservations and exceptions, ladies and gentlemen, are extremely, extremely broad. The reservations and exceptions, one series of them is in 1604, and another series is in the 1800s, are extremely, extremely important. But they create a very vast area for public purpose. Because practically everything and anything that you can imagine is contained in the NAFTA in these reservations. So we took these reservations and we said, what meaning can all these reservations and exceptions that the parties negotiated have in a public purpose context? What meaning can it possibly have? And this is just the result of negotiations. So we reserved it and we said, all of the annexes to the NAFTA and all of the general reservations to the NAFTA really constitute a special category public purpose. Why is it a special category public purpose? Because formally, it has the legitimacy of having followed a protocol, if you will, of having followed a process, which it did. But substantively, many of these subject matters are so narrow and so precise that you would never think of them as being a public purpose. They're just simply too broad and too general in other respects, too outside of what you would think would be the reasonable exercise of regulatory sovereignty, even in the context of what is basically a trade agreement. This creates some problems, because the NAFTA, and we thought this was also very good that it created some problems, because the NAFTA says if there's ever a conflict between a trade provision of this treaty and an investment protection provision of this treaty, the trade provision shall prevail. And this also we find in public international law, because of course public international law is much richer with respect to trade issues and much more developed, I venture to say, with respect to trade issues than they can ever aspire to be with respect to the law of investment protection. It's just simply on reality. So in this sense, the NAFTA also mimics what we see in the world of public international law. But the NAFTA, unlike any other treaty, does something that's also extremely special. It does not define public purpose, but it has something that's better than a definition of public purpose. It has a standard for public purpose. And regrettably, I don't have the copy of the treaty here with me, but I don't need it, don't worry. The standard that it has for public purpose mentions police powers, education, health, insurance, and security, these types of matters. And it has two words which are the most important part of the standard, and the reason why I call it a standard and not a definition. The two words are the words such as. It lists these categories, and then it says such as these. The NAFTA drafters were sufficiently clear with the vision that you could not define public purpose, but you can just have a standard and refer to that standard. And by the way, generally speaking, this is a vast improvement. This is like no other piece of international work that you could ever have or find, because everything else doesn't even treat public purpose with any seriousness. In section 1110, the NAFTA has the standard for expropriation, and it has the same standard that you're now extremely familiar with the four basic elements. And of course, one of those is public purpose. So we found that this was all very good until we started looking at it a little closer, and we saw that the case law following the NAFTA, instead of sharpening and making these points much clearer, which is what you think case law and jurisprudence would do, it didn't do that at all. It made, I think, the standards of protection much more unintelligible. And it really did not develop public purpose at all. There are two very important cases in the constellation of the NAFTA. One is Methanex, as the other one's called Benelplat. I won't get into the facts of the cases, and I won't bore you with them. But suffice it to say that when you look at those cases, they come out in different places, even though, and you don't have one standard. and it's not transparent. That's why when we started our conversation yesterday, I said to you, I think that it could be possible to come up with algorithms that could ultimately tell you how many cases are going to be won and how many cases are going to be lost if we use the same rubric of domestic law and international law. The reason why you have Methodist and middle class coming apart, having diametrically opposing positions, is very simple. They're using the domestic causation model. And then they're taking that causation model and just modifying it. But after you read the cases, and if I were to say to you, well, what is it about a regulatory act that is not permissible and therefore should be punished? You still won't be able to articulate. So long as we have this foundational problem, we're not going to have the type of equitable administration of justice and public international law that we need. You'll just be able to recite a test that says, oh, well, look, there was damage. Well, how do we treat that damage? Well, let's bring in other factors. Was this damage foreseeable? Well, what do you mean when it was foreseeable? Yes, was there a reasonable expectation for the damage? Well, under what circumstances? The problem is you're still with the old model. Now, I'm not saying discard this old model. I'm not saying that. I'm saying contextualize the old model. One thing that we find that is very, very helpful with the NAFTA is that the NAFTA does seem to provide for a hierarchy of public purpose, believe it or not. And it seems to suggest that the public purpose having to do with health, education, national security, child care, and police powers, and other similar public purposes from the orthodox model that we know, that those are the supreme public purposes. Now, what practical effect does this have remains totally opaque. So we found that in the microcosm of a self-contained trade agreement having an investor protection component to it, we grow no closer to an understanding of public purpose. And it's no different than just getting a sampling of water from a lake that is contaminated. Nothing new really is found. So, where are we? What we suggest is 11 prescriptive ways of addressing public purpose. 11 ways that, of course, are not exhaustive. And we will talk about these in a second. Before doing that, I want to talk about an aspect of this entire regime that has been completely ignored and which we feel is extremely important. And these are what we call FIPS, F-I-P-S, Foreign Investment Protection Statutes. And the Foreign Investment Protection Statutes, ladies and gentlemen, are ignored. What do I mean by that? Well, you find very little reference to them in international arbitral awards. Very little reference to them. To the extent that you find some reference to them, it's generally on the issue of whether they provide an independent basis for jurisdiction for filing an arbitral claim. Does it represent an invitation to file an arbitral claim that can be, or an offer to file an arbitral claim that can be accepted simply by filing the claim? But everyone ignores it. Now, Turkey also has a foreign investment protection statute that I'll talk about in a second. And what we have found is that in these foreign investment protection statutes, they are, do you know what a petri dish is? It's forget about what it is. It's a dish that's used to cultivate
Petri dish, yes.
Yeah, it's, we find that they are great models for understanding public purpose. All of these statutes have a public purpose component. But the gamut, the range of these statutes is so broad that you can really have to ask yourself, what is happening? They're decentralized completely. In that sense, these foreign investment protection statutes mirror the BITs. The BITs are also decentralized. The foreign investment protection statutes have some of the information, some of the protection standards in them, but they're applied differently if applied at all, and they're qualified in different ways. And a foreign investment protection standard in a foreign investment protection statute means something different depending on the statute. In the BITs too, because it's not centralized. There's absolutely no harmony to it. So you have BITs that have different protection standards. You have BITs that have different definition of the existing protection standards. You have BITs that don't have the same protection standards, and it's the same country. And we found the same thing with the foreign investment protection statutes. Let me tell you what else we found. The foreign investment protection statutes are completely divorced from the BITs. They don't reference the BITs. And we find that for a country, for any country, but certainly for a country like Turkey, developing this statute is critical and can provide very interesting methodologies for construing, for interpreting the terms in your bid. Now, these statutes, I told you, have a wide range of language with respect to public purpose and otherwise. For example, is anyone here from the People's Republic of China? Okay. I don't want to talk bad about the Chinese, that's not why I asked the question. What I wanted to say is the People's Republic of China has a very curious foreign investment protection statute. I'm going to tell you what it says, more or less. I don't speak Chinese. But I'll tell you what it says, because it's translated in every language in the world, and it's translated in my book. And you can see it there. But it says something like this: come to China. This is a great place. And we invite you to come here. And when you come here, can you do us a favor? Just follow the laws. And you can invest here, and this is really, really good. It says something like that. I mean, what it protects and how it protects it and what are the rights are not clear to me at all. And then you have other more severe foreign investment protection statutes that will say things like, you know, if you come here, of course, we'll protect you, but, you know, but we may take your property in these 17 different ways. You know, it's not really an incentive to go to the country. I want to read to you some of these, language from some of these that I think may be helpful, so you can understand it. And then I'm going to, and I want to not only read it, I want to analyze it with you. And then I want to turn to your foreign investment protection statute here in Turkey, which happens to be law number 4875. Have any of you ever seen that legislation? Did anyone here know that we have legislation for the protection of foreign investment?
Yes, absolutely.
Yes? Good. Are you familiar with it at all?
I didn't have a chance to read the code, but yes, the professor actually has also understanding on the subject.
Professor, please feel free to intervene at any point. We're going to look at it. We're going to look at it, and then we're going to look at the Turkey-U.S. Free Trade Agreement and the Turkey Azerbaijan treaty. Let me give you some language here that I think is very, very interesting. This is from, ladies and gentlemen, this is from the Vietnam, and if we want to follow to page 324, this is from the Vietnam Foreign Investment Protection Statute. And it says this, remember I'm looking at just the public purpose component, so I want you to see that. It says, quote, in case of real necessity for purpose of national defense and security in the national interest, if the state acquires compulsorily or requisitions an asset, no, I'm sorry. It's not, it's in
It's in the book.
It's in the book. I'm sorry. Do you have it? Do you have it? Okay. So again, in case of real necessity for purpose of national defense and security, and in the national interest, if the state acquires compulsorily or requisitions an asset of an investor, such investor shall be compensated or paid damages at the market price at the time of announcement of such compulsory acquisition. Now, I think that this is a very interesting and a very reasonable, this part of the public purpose statute, as I explained in the book. Notice that it's limiting it to national defense and security, and tying it, of course, to the national interest. This is a very narrow way of saying, look, we can expropriate you in this country, but it's only, you know, if there's national security interest. Let's go back to our paradigm. It's very difficult to justify the expropriation if you have that statute on a public purpose basis here. Isn't it? For example, let me give you another example that I think is very, very helpful, which is the Egyptian example on page 325. It's a single sentence article that states, quote, 325, companies and establishments may neither be sequestered nor may their assets be subject to administrative attachment, seized, restrained, frozen, or expropriated. Just reading from the book, just the textual, it says, Article 9 contains the first reference to the term administrative in any form, and although its presence opens the door for the possibility of a judicial attachment, seizure, etc., restraining orders, freezes, an asset exception, it is the exercise of regulatory authority through administrative agencies that historically seizes assets. In other words, the Egyptian public purpose is even better in some sense. It only has one ambiguity, and that ambiguity is what I mentioned, that it mentions administrative and not judicial, and some creative mind may say, well, you know, that seems to be somewhat problematic because maybe judicial is not covered. But that's highly unlikely. On the next page, you'll see that the Egyptian law goes on and says, which I think this is very good. No administrative authority may cancel or suspend in whole or in part a license for usufruct of real estate which the company or establishment is licensed to utilize, except in case of breach of the conditions of the license. A decree terminating or canceling a license shall be issued by the Prime Minister upon the proposal of the administrative authority. The involved parties may challenge such decree before the administrative court within 30 days from the day of notification or acknowledgement thereof. You may think that that's problematic, and it may be problematic it may be problematic, because it says that if there's a contractual breach, then it can go back. And it basically limits or places at the level of a contractual breach the state's ability, in effect, to possibly engage in an indirect expropriation. I mean, let's be adults about this. If you're dependent on a license for the business to operate, and you take the license away, that's what value will the license have? It'll be extremely limited. But one aspect of this that is somewhat comforting is that obviously they're trying to say it has to go all the way to the Prime Minister. Obviously they're trying to say we will take this extremely seriously. This is not just a light affair. And that is something that I think is also extremely helpful. Let me read one more. The Lao People's Democratic Republic excerpt from their statute. It says, the government fully acknowledges and protects the investment of investors against seizure, confiscation, or nationalization by administration processes. In the case that the government has the need for public interests, the investors shall be compensated with an actual value based on market price at the time of transferring the money, and the payment method is agreed by both parties. The government acknowledges and protects the intellectual property of registered investors in accordance with the laws of intellectual property in the Lao PDR or international treaties to which the Lao PDR is a contracting party. You see here, ladies and gentlemen, that despite the first sentence, which purports to be kind of tight, it talks about need as being the governing standard for a public purpose. And, you know, need is not necessarily altogether all that clear. I want to share with you the Turkish statute. And again, this is law number 4875. It was date of passage is June 5, 2003, and it was date of the official gazette is June 17, 2003. And it has an expropriation provision on Article 3 that says expropriation and nationalization. Foreign direct investment shall not be expropriated or nationalized, that's covered, except for public interest and upon compensation in accordance with due process of law. What are your thoughts on that? Are you fine with it? Can you improve it? If you're a foreign investor, do you feel comfortable with it? Do you think it helps you somehow in treaty interpretation? Any thoughts? Yes, please.
It seems the countries give the first height public interest, and they every country, I think, give firstly public interest importance. They give importance firstly to public interest, but it's so openly. I have a lot of question marks at my mind. What is the public interest and what is the best for the public? And so I don't feel comfortable with this.
Any thoughts? Yes.
I think the investors need to be supported by the government. In this point, I think public public purpose cannot be subjected to this point. And also, my friend said because of that, the government has the need of the public interest.
If you compare it to the Egyptian or the Vietnamese or the Lao statute, then you see before you even get to public purpose. Notice that some of these statutes talk about what the compensation will be, which I think would be an important part of the purpose of the statute. What's the purpose of a foreign investment protection statute, ladies and gentlemen, in your mind? What should this statute, why do countries enact these statutes, do you think?
To attract investors.
Yes, obviously to attract investors. Is that a statute that you think can be improved in terms of attracting investors? If you were to add to the statute, let's say, the statute says, foreign direct investments shall not be expropriated or nationalized, except for public interest. Now, stop there. If you were to say, except for public interests, such as national security, fighting terrorism, and healthcare, would that help the statute?
Yes.
I have to believe you're turning it either into a standard, like in the NAFTA, or you're just qualifying. And those are just like 4 or 5 words. And what about if you continue with it and you say, except for upon compensation, and it says, the statute says, in accordance with due process of law, and right after compensation, you say compensation, and you say, which shall be the full fair market value of the property. And then the other issue becomes, just think about this. When property is taken, what happens to the price of the property, the value of the property? Of course, it turns into rubbish, nothing. The state took over the bank. What's the bank worth? What are those shares worth? Nothing. So what if it says, and such compensation will be in keeping with the fair market value of the property 2 months before the expropriation was announced or made public. Now you're starting to talk. Those are just a few words. Those are just a few words. I'm sure we can come up with better words. But this is the type of thinking that I think is important and that makes sense. Let me show you something about the treaty, bilateral investment treaty, about the Turkish bilateral investment treaties. Remember I told you there are 145 and about 100 are enforced. I just want to point something out. I think you should have this piece of paper together with, I think, a 1,500 piece of paper I gave you. But let me tell you about, you don't need to pull it out. If you can find it, all the better, because you can look at it yourself at the time. But I pulled out and I made this chart. I'll give you a couple of minutes here to find it. Do you have it? No? I'll circulate it. Here's what I want to share with you. Here's what I want to share with you. I'm now pulling before you the Azerbaijan, Turkey bilateral investment treaty. Now, let me just say a couple of things. In 2017, one of the reported figures for Turkey for GNP was 851.1 billion. $851.1 billion. For that same year, in Azerbaijan, ladies and gentlemen, the number was $164.2 billion. You see the difference? It's just a completely different order of magnitude. Let me give you another statistic that I think is extremely interesting. For 2016, 2 years ago, the average life expectancy in Azerbaijan, ladies and gentlemen, was the age of 72.03 years of age. The life expectancy in your country, the Republic of Turkey, was 75.76. Those 3 years, you may say, well, it's just 3. 3 is a small number. No. In this world of life expectancy, 3 years as an average is a lot, because it's an average. And those numbers are the product of many factors that go into it. Clearly, who is the capital exporting country and who is the capital importing country of the treaty, ladies and gentlemen? Yes, sir.
I think this situation could be a little tricky because I think Azerbaijan has lots of investments in Turkey, including they recently opened that is worth $6 billion refinery. So this case could be a little bit different than what is expected.
Okay, let me ask you this. What's the year of that investment?
This year.
This year. That's extremely helpful.
Total investment is 10 billion. Azerbaijan investments in Turkey, if I'm not mistaken.
That's very helpful.
These investments were made by state-owned company of Azerbaijan.
I'm sorry?
These recent investments were made by state-owned company.
State-owned company.
Azerbaijan company, yes.
That's also very interesting too, because it's a state-to-state and not private. No, do we consider it or no?
I'm not sure. Azerbaijan is an
You're
interesting country.
What about this? Does it make a difference in your mind's eye what that analysis is if the treaty was signed and preceded the investment by 7 years? If at the time of signing the treaty, that investment did not exist, do the relative positions of power of the two signatory states matter to you? Or no, it doesn't?
I mean, it doesn't matter, of course.
Let me tell you a couple of things I think that you'll find very interesting in this treaty. The Azerbaijan Treaty has exceptions in Article 5, general exceptions. This is extremely rare in the configuration of bilateral investment treaties generally, and particularly in the example of Turkey. Those exceptions say this: nothing in this agreement shall be construed to prevent a contracting party from adopting, maintaining, or enforcing any non-discriminatory legal measures, and then they have a whole gamut. Apply for the protection of human, animal, and plant life, or health or environment, related to the conservation of living or non-living exhaustible natural resources. Nothing in this agreement shall be construed to prevent any contracting party from taking any action that it considers necessary for the protection of its essential security, relating to traffic and arms, conditions, etc. And of course, it goes down to things that are very important, such as the proliferation of weapons and other ones. But the first half is extremely broad. Now, I took a sampling of 1, 2, 3, 4, 5, 6, 7 treaties that Turkey has with Italy, Azerbaijan, Korea, Denmark, Greece, the United Kingdom, and the U.S. It only has these exceptions on Article 5 with Korea and Azerbaijan, which is very interesting. Let me just say that in terms of expropriation, Turkey has it with all of the samples that we have, national treatment with all of the samples that we have. But discriminatory measures, it doesn't have discriminatory measures with Italy. International minimum standards, listen to this, only with Azerbaijan, not with any of the other countries, not with Italy, Denmark, Korea, Greece, United Kingdom, or the U.S. Full protection and security now with Italy, but yes with all the others. Transparency provision, yes with Azerbaijan, no transparency provision for any of the others. National or international law, incorporation of national international law, it has it with Denmark, Greece, and the United Kingdom, but not with any of the others. Effective means one of my favorite standards of protection. It has it with none of the others, but yes, with the United States. Of course, with the United States has to be viewed as a capital exporting country, and Turkey as a capital importing country. But what does that mean, effective means? Effective means is something called a special law. And it's a special law, meaning that in its origins, it's a treaty-based law that basically says that if you're not treated right, or if you're treated egregiously, and in that sense denied the effective means of justice within the judicial system of the host state, then you can bring a claim. So that provision, that special standard of protection, that, by the way, in the entire galaxy of bilateral investment treaties is very, very limited. You find in none of the sample treaties, but yes, in the United States. Why? Because the United States obviously had a concern with preserving this standard of protection, and the investors had it. And now the question that I want to pose to you is a very simple question. I just looked at these, what was it, 7 countries, or 1, 2, 3, 4, 5, 6, 7, 8 countries, I'm sorry, these 8 countries. You've seen the differences in the different standards of protection that are in some and not in others. Shouldn't we have, or aspire to have, a uniform treaty system from the country? Wouldn't that help? Yes, sir, please.
Initially, I would say no, because one of the aspects of facts that you never presented, like the details of Turkey within other countries' agreements. It has something to do with the political climate of the country as well, and the ties that have developed throughout the years, where that is having a uniform application would be, in my opinion, not realistic.
So you're saying that's a very good observation. Let me tell me if I'm putting words into your mouth. You're saying, look, there are a number of variables. Not only the fact that each country is separately negotiated, but perhaps each treaty is negotiated in time, historicity, in different historical moments, bring different exigencies and different concerns and different objectives. Also, the relationship between the two countries at issue is going to be always different depending on the other country. Turkey and the United States has a different set of priorities, a different dynamic, a different goal than Turkey and Azerbaijan. So that's just to cite that example. We may be very interested in having our investors go to a particular country, but those interests cannot be compared with attracting foreign capital from countries X, Y, and Z. That's basically your argument, correct?
Exactly.
And I think it's a very good and very compelling argument. Let me ask you and invite you to consider another set of arguments. What if Turkey were to say, I don't like the system. I don't like the system for whatever reason. Let's say Turkey agrees with me and says, I don't like the fact that these standards of protection are treated differently depending on the country you're in, depending on the arbitral tribunal you get, depending on the treaty you have, that the very words contained in a different section of a treaty have a different application altogether, that some of them are qualified. And let's assume that Turkey said, we're just going to have 2 types of foreign investment treaties. Bilateral investment. We're going to have a model bilateral investment treaty for all the states where we contemplate that our citizens, our nationals, are going to be the investors. And we're going to have another set, which will be the bilateral investment treaties where we will give up, where we will assume more standards of protection, because we want to attract that foreign direct investment. How about that idea? And let me make the question a little bit more complicated. Let's assume that Turkey says, not only that, here's what we're going to do with all of our treaties. We're going to redo the Foreign Investment Protection Statute, and we're going to define some of these terms. We're going to say we understand this public purpose to mean X, and we're going to and we understand this standard of protection to mean Y. And let's assume that they use the Foreign Investment Protection Statute to strengthen the language. So now, if there is a claim against Turkey, Turkey can say, no, investor, that's not what we meant by fair and equitable treatment or by national treatment. That's not what we meant. You knew what we meant. And you knew what we meant before you ever came here. Because it's in our statute. Why not harmonize in many different possible ways the Foreign Investment Protection Statute with your treaty system? Why just keep them separate and distinct? By the way, what relevance will that statute have? Now, before closing for today, I want to say something that hopefully will be shocking to you. Did we get time?
No, trying to assume what you were going to say.
Oh, okay.
But I'm not going to.
Oh my God, remember I told you I couldn't find the napkin? You were grabbing my pen? And I was sweating bullets. Trying to get that stuff. I want to tell you something that I did in my free time. The whole purpose of the foreign direct investment, gosh, I don't know if I should say it. Yeah, okay. The whole purpose of the foreign direct investment regime is to attract foreign direct investment, right? The whole purpose of having the treaties, the whole purpose of having the foreign investment protection statutes is to attract foreign direct investment. And that's what we said was being discussed in 1961 through 1965. And I told you that I have the papers here, and I do. They're right here from the World Bank. The contemporaneous notes that talk about bringing in foreign direct investment. It's all right here. We can go through it if we had more time. For the present moment, I just ask that you take it on faith. But if you want to, I'll send you this material. It's very, very interesting. Now, I started this class by saying that I want you to think. All along, you and I have been assuming that foreign direct investment is tied to having these treaties and these statutes. And that there is an empirical basis for identifying the flow of foreign direct investments with a treaty network. Remember? We took this for granted, didn't we? We said, of course it makes sense, doesn't it? After all, if the fear is the foreign courts, that's been resolved. And now, foreign direct investment flows everywhere because everyone's secure, because they know these treaties are in place. Now let me tell you this. To date, there are 18, that's the year, well this one came out yesterday. There are 18 empirical studies that I've looked at, which are all the empirical studies, on the relationship between bilateral investment treaties, multilateral treaties having investment components, and the flow of foreign direct investment. Let me tell you where we are on that issue. We've identified 18 studies. When you read the studies, by the way, the 18 studies, and I can give you the numbers of all 18 studies. the studies cannot be reconciled one with the other. So the studies conflict between and amongst themselves. 3 of the 18 studies conclude that some investment treaties increase FDI. 3 of 18. 3 of 18. 2 additional studies, now we're in 5. 2 additional studies report ostensibly contradictory findings. One says that only U.S. bids increase co-signatories' FDI. So they're saying only when you partner, only when you have a bid with the U.S. would the foreign direct investment increase. There's another study that says if you have a bid with the U.S., foreign direct investment decreases. Says it. 2 additional studies find, respectively, that, quote, only minor and secondary and, quote, slight relationships between investment treaties and FDI are discernible. 6 studies reject the hypothesis that investment treaties increase FDI. By the way, we saw additional methodological problems in all of the studies. We think all of the studies are extremely problematic. By way of example, they do not really identify the financial flows of FDI with sufficient specificity so you can have good scientific data to rely on from an empirical perspective. They don't address whether bids having compulsory investor-state arbitration provisions do better than those that don't have it. One scholar writes the following on it. He says, quote, more recent studies tend to address concerns in a more sophisticated way. However, aside from one study that finds a large effect, which is Carter, why should I believe you? The name of the study, page 1. These studies tend to find only minor effects of investment treaties on FDI. Tobin and Rose Ackerman, I knew Rose Ackerman back from the Estonia law school. She was married to Professor Ackerman, who was my constitutional law professor. When bids have some bite. And it goes on and says that many of these studies find that only some investment treaties are effective in attracting FDI when they are inconsistent with one another as to which subset of treaties are effective. Citing more authority. Finding that bids are most effective in developing countries with good institutional quality. It goes on and on. I can talk to you more about this in the next class, but here's what I want to let you know. What I'm going to propose to you is that this relationship of power, under my theory, if followed, is inverse. The person who has, the entity that has the power, is the host state, the poorer state, the capital importing state. I'll see you tomorrow.